video controls, main jail. I need Shatara Cheney, main jail.
Shatara Cheney, Your Honor, I've been advised she has a private attorney.
Yeah, he's here in the courtroom.
Oh, here he is.
All right, good morning, ma'am. You're charged this morning with, or this afternoon with touching or striking during a domestic violence event. I reviewed the probable cause affidavit. Your attorney is present in the courtroom. I find there's probable cause to believe you may have committed the offense to which you're charged. Anything you want to say, counsel? And you, tell us your appearance, please.
I do, Your Honor. Good afternoon. Carter Hillstrom on behalf of Shatara Cheney. I had given a copy to the state an affidavit from the complaining witness, a sworn waiver of prosecution. I believe that the state provided it to the court.
No, I haven't.
I did, Madam President.
Sure.
Decline.
It's basically a bare bones affidavit that he's not in fear of Ms. Cheney, and the complaining witness does not wish to prosecute and does not wish a no contact order, which is consistent with what is in the probable cause affidavit. The court will note that the police were reduced to talking to waiters and other employees at this restaurant, which I cross-referenced and is a Wings Plus in Coral Springs. The complaining witness, not even complaining, but the alleged victim, Mr. Desanor, told police he did not wish to prosecute, did not wish to cooperate, did not wish the charges were filed against Ms. Cheney, yet it happened anyway. So we'll stipulate to PC for the purpose of this hearing. I would just ask the court, in light of the fact that I strongly doubt that this case will ever be filed at a bond of $500, be set.
Anything you want to say?
Your Honor, as far as bond, I really have no position. I'll leave that solely in the court's discretion. I would ask, though, for the time being, that there be a no contact order to ensure that this does not occur again during the pendency of the case.
All right, I'd already written on the bond, $500 on the bond based on the allegations in the BC. I am going to, in an abundance of caution, sir, issue a no contact order that she not have any contact during her release with Sentinel, Desanor in Coral Springs, and you'll have to resolve this case with the division judge. So $500 on the bond. Good luck to you, ma'am.
Yes, sir. Thank you.
Thank you, counsel. Have a good day. All right. Anybody else? Sidebar real fast. I don't have sidebar. System on it, go. Okay, main jail there. I'm going to call a case out of order. Jennifer Ingram. Anybody know where she might be?
No.
Anybody know? North Broward?
There's no Jennifer Ingram at Maine.
Paul Ryan.
Paul Ryan, thank you.
All right.
You might
Paul
have.
Ryan, are you there? Is there a Jennifer Ingram there?
She's on her way down right now, Your Honor.
All right. I'll recall her case in a minute then. I'll move to the next case.
See it?
You just let us know when she's there.
Okay, I got it right.
The next case is Betty Tyler,
She's here present at Maine, Your Honor.
Do you have any paper
touching or
clip, please?
striking during a domestic violence. I've read this probable cause affidavit. All right, this is a strike on the right eye. Simple battery is what you're charged with, Ms. Tyler. I find probable cause in the case. I'm going to set the bond at $500. Should you make this
Your
bond-
Honor,
Yes, sir. Should you make this bond?
I know she has,
Go ahead, sir.
Yeah.
I'm sorry.
I'm sorry, I know Ms. Tyler's been here for 30 years, Your Honor. South Florida, financially, she has no money, she owns no property. She is a caretaker, that's her part-time employment for the past 14 years. Her family lives in Florida, so she has ties to the community. Would you consider a $100 bond?
Thank you so much. All right, bye.
Does she have any kind of record, Mr. Attorney?
Your Honor, the only thing I saw was a DUI with a breath over a .15 and possession of marijuana from 2010, violation of county ordinances in '03.
My understanding is the alleged victim, I believe it's from upstate, I believe in New York, Your Honor, and she was down visiting, so I know that person's going back, so there's no sort of concern relating to the victim, any sort of victim contact, Your Honor. So we'd be asking you for a $100
There
bond.
is a statement that the victim did not want to prosecute. I'll set the bond at $250 and order no contact between the defendant and Addie Stanley. That means you can't have any contact with her directly or indirectly, ma'am. I'll set your bond at $250. Good luck to you.
Thank you.
Your Honor, Paul Ryan has Ingram.
Paul Ryan, thank you. All right, your name is Jennifer Ingram.
Yes, ma'am. Yes, sir.
Okay, this is a second look, right?
Yes, Your Honor.
You're already out on bond on some other offense, is what I understood from the cases here. There's a defense motion for an ROR on 11/24, right? Is that what this is about?
It's not really, Your Honor, it's a second look to review if there are any alternative release conditions the court can set. My understanding of bond has been posted. I also think it is possible that it might be in the defendant's best interest to have pretrial also. My understanding is, and I see she has had drug priors in the past.
Okay, ma'am, if I place you on pretrial release, you must understand that you must follow the conditions of pretrial release, which will likely include passing urinalysis, random urinalysis, and whatever other requirements they set. Going to be able to comply with those rules if I place you on pretrial release?
Absolutely.
All right, well, you need to make sure you apply with these rules, because if you fail these drug tests, they'll probably take you off pretrial release, and you'll have to come back to establish a bond or whatever might occur.
And Your Honor, you're adding this onto the bond that has been posted.
Adding this on to the bond that's already been posted, so you'll be placed on pretrial release on that.
Thank you, Judge.
Your Honor, my question is the following.
Pretrial.
Your Honor, my question is, if she's
right,
in the
thank you,
process of bonding out and it's currently pending, then at this time, we would ask you to reconsider not placing her on pretrial if she's already posted bond, Your Honor. Second look usually means that they're in here for like a not so significant offense, and it's an opportunity for the court to reconsider and ask why the person hasn't bonded out, and if the person cannot afford a bond out, then to reconsider pretrial, or in the alternative, potentially lowering the bond or placing the person or dismissing the case, Your Honor. It's not
Okay.
to go ahead and enhance it.
Okay, sir, I have the bondsman here in the courtroom. The reason I did this
Uh-huh.
is at the request of the bondsman, based on her,
So the bondsman requested it
Your
when
Honor,
she's giving business to the bondsman?
okay, sir, can you just hang on a second?
I'm sorry.
Yeah.
Yeah,
It's kind of an inappropriate way to address me, so please don't do that.
I'm sorry.
All right, let's start again. Mr. State Attorney.
Your Honor, it's also at the state's request, and the court has in the past, when Judge Hurley's covered other judges, that they have added conditions, even when a bond has been posted, of pretrial release. Judge Hurley has had concerns that there could be drug issues, and has added pretrial release as another, thank you, as another safeguard to ensure that the person's behavior while the case is pending. It wouldn't be the first time that it's
What's the
happened, Your Honor.
person's bond?
I believe it was it 1,000? 4,500. And Your Honor, I do believe actually the court can, considering that the bondsman is the one that is putting, is securing this person's future appearance in court, I certainly think the court can take into consideration any information or testimony that a bond agent has to provide, which he has.
I mean, I'm just inclined just not even take a second look at it and just to leave the bond in place where it is, and you guys sort this out yourselves. If you don't want him on pretrial release, you want to object, that's fine. I'll sustain your objection. No pretrial release, no second look. He'll remain on bond. What did I do with it? I don't think I hit it. No action. Okay, so she'll just stay in jail, or she'll be under the bond. Okay, the next case is Timothy Harper. Timothy Harper.
Timothy Harper. He's coming up, Your Honor, main jail.
Thank you, counsel. This is a shoplifting case. You're charged with petty theft. I did review the probable cause affidavit. The phone charger value was $14.88 recovered. There is probable cause to believe you committed the charge of petty theft. However, there's also a warrant for your arrest based on a violation of probation allegation out of the circuit court by Judge Cohen. On count 1, the bond is $25. On count 2, there is no bond. You'll see the judge on December 1st at 9:30 a.m., sir. All right? Good luck to you.
You'll be seeing the judge December 1st at 9:30 a.m.
Maria Edwards Ramos.
I've been informed, Your Honor, that she bonded.
That's what we heard. Thank you very much, sir.
Your Honor,
Yes.
possible, on our victim advocate, there's only one case left for her. Richard Haynes from this morning.
Richard Haynes, yeah.
I left a message with the attorney, the name of the attorney he gave. Well, I'll wait till he gets up there.
Richard Haynes, a private
Richard
lawyer.
Haynes?
We can't raise your private lawyer. I don't have his paperwork here. Mr. Haynes, we're not able to raise your lawyer. We've tried several times. So, I'm,
Your Honor, and pursuant to the rules, it's really his choice at this point. If he wants to proceed with the public defender at this time so that Your Honor can set a bond on 1 and 2, that's his right. I see that the public defenders filed a notice of appearance on counts 3 and 4. If he wants to have it reset so he can have another opportunity to contact his attorney tomorrow, that's his right also, but it's his choice to make.
you want us to try to get your lawyer here tomorrow, Mr. Haynes?
Let me ask you, if the public defender is there, would I be issued a bond today?
Yes.
Well, I'm going to set the
Could I be-
bonds. I'm going to set the bonds if you want bonds set in these cases. There's already.
Yes.
Is that what you wish to do, for me to set the bonds and determine probable cause without your lawyer here?
Yes, Your Honor.
All right, well, I've already reviewed these this morning. Okay, first off, remind me again, Mr. State Attorney.
Yes,
He
Your
had
Honor.
2 bonds set for $7,500, which the bondsman declined, or asked him to surrender the bond, right?
He returned them when he was arrested on counts 1 and 2.
So he's going to have to file those bonds again if he wants to get bond on those last 2 counts, right?
Yes, Your Honor.
All right, so you already know, sir, you have 2 $7,500 bonds in place on counts 3 and 4 that were surrendered by the bondsman. You're going to have to reinstate those bonds if you want to bond out on those 2 charges. On count 1, yes.
I'm sorry, I want the court to be advised. The alleged victim on counts 1 and 2 is the same as the alleged victim on counts 3 and 4.
In count 1, you're charged with battery, second or subsequent offense during domestic violence. In count 3, a violation of an injunction for protective for protection in a domestic violence dispute. There's probable cause to believe he may have committed both of those offenses. Give me his record, please, if he has one.
Yes, Your Honor. 2003, criminal mischief with the violation of probation. 1996, aggravated assault with a deadly weapon, battery, 2 counts of criminal mischief. 1996, resisting without violence.
All right, in count 1, I establish your bond then at $7,500. Count 2, the bond is $5,000. Then your total bonds are $7,500, $5,000, and the 2 $7,500 bonds that were existing before today. Good luck to you, sir.
Your Honor.
Thank you, Your Honor.
Should you make these bonds, sir, you have no contact with the alleged victim in this case, which purports to be Keisha or Kishma Haynes in Coral Springs, Florida. Do you understand no contact directly or indirectly with her, or family members, or anyone else to try to contact her?
Yes, Your Honor.
Good luck to you, sir. All right, we'll take care of Mr. Haynes. All right, back on the regular body. Josie Smith. Josie?
North Broward, Your Honor.
North Broward, thank you, counsel. Josie Smith, thank you.
I think it's Eric.
I was able to interview Ms. Smith.
Okay.
Per my interview with her, she mentions that she's never been arrested.
Okay.
She has no priors. She is a graduate of University of West Georgia. She's lived in South Florida for about 2 years. She's received her bachelor's degree in business. She currently works in sales. She would like to see if the court would consider pretrial release. She says with regards to the incident, she was merely a passenger initially. The person that was driving the vehicle was under the influence, and so she asked him to pull over so that she could drive, but at no point did she have any knowledge that the car was stolen.
All right, you're charged with grand theft. I find probable cause on the count. Does she qualify for pretrial release, madam? Okay, ma'am, do you have a permanent address?
Yes.
What is,
Yes.
what is it?
629 Northeast 2nd Avenue, Fort Lauderdale, Florida, 33304, apartment number 2.
How long you lived at that address?
Since May,
You work?
I do work.
Where?
I'm a sales rep for independent fashion lines, and I bartend.
How long you lived in Broward County?
A year and a half, almost
Yeah.
2 years.
Do you have any record?
Not that I see.
Okay, ma'am, I'm gonna place you on pretrial release. You need to make sure they have a valid full-time address for you, and you pay close attention to all of their requirements and comply with all the pretrial requirements of pretrial release. Do you understand?
Yes, sir. Thank you.
All right, you'll be released. Good luck. Alberto told you? Alberto, Soldiew. All right, good morning, sir.
Yes.
Sir, you're charged
Good morning,
with
Your Honor.
DUI or drugs first offense, DUI
Yes,
with
Your Honor.
damage to person or property of another, and failure to use due care, which is a traffic violation. Give me 1 second, please. All right, sir, there's probable cause to believe you may have committed all 3 of the offenses to which you're charged. Sufficient probable cause on the DUI. You crashed into the security gate. Sufficient probable cause on that. Does he have any record?
Your Honor, I see prior arrests out of Virgin Islands, but I don't have dispositions on any of them.
Okay, on count 1, your bond is set at $500. Count 2, I'll reduce that bond to $500 as well. Your total bonds will be $1,000. You'll have to post those bonds and see the judge, sir. Good luck to you.
Thank you. Thank you.
Justin Cohen, Justin, where are you?
Good afternoon, Your Honor.
Good afternoon, sir. You're charged with possession of cannabis, 20 grams or less, and also drug paraphernalia.
Yes.
All right, this was during a search of the residence. 15 grams of processed cannabis. Positive test. Okay, there's probable cause to believe you may have committed both of these offenses. Does he have any record?
No, sir.
Your Honor, I have information to share with the court.
Hang on 1 second, sir. Mr. State Attorney, any record?
One moment, Judge.
While he's looking, how long you lived in Broward County, sir? Oh, I'm sorry, Mr. Public Defender, I cut you off. What do you want to say?
He's 27 years old, Your Honor. He's a graduate of Nova University in 2011, Your Honor. He's financially only has $100 in the bank. He is employed. He's working at West Marine Water Sports. He's been in there. He's been employed for the past 4 months, making $12 an hour, Your Honor. He has an address in Davie. That's where he resides. We'd be asking to consider ROR.
What is your permanent address, sir?
My permanent address is there in Davie, sir.
What's the
What
answer?
is it? Tell me.
2400 Southwest 31st Street, apartment 306.
Okay, and how long you lived there?
About 4 months.
And how long you employed with this employer you're with?
4 months since I've been back in the state, sir.
Mr. State Attorney.
Your Honor, I don't see any
I'm
priors.
not going to ROR him, but I will place him on pretrial release. You got to follow all of the requirements of pretrial release. You got to pass your analysis. You going to be able to do all that, sir?
Yes, sir, of course, Your Honor.
All right, you'll be placed on pretrial release. Good luck to you, sir.
Thank you very much, Your Honor.
Your Honor, considering the time, he's probably going to be released really late today. I don't think he'll be able to be to go to report today. So can you have him report by 9 a.m. tomorrow?
Well, how about noon tomorrow?
Oh, okay, new. These are the instructions how to get the pretrial. This is the address. Thank you, Your Honor.
Thank you, Counsel. Sherman, Alexandra.
You're good.
Davies.
Mr. Alexander, come on up.
This is self-surrender, trespass. Does he have a record?
I'm not showing anything, Your Honor.
Nothing?
No record, Your Honor. I have information to share with you.
All right, so what would that be?
In speaking with Mr. Alexander, he's been in South Florida for the past 20 years. He's a graduate of Deerfield High School, Your Honor. He did attend Everest University. He is pursuing a degree in hospitality. Your Honor, he lives with his father in Pompano, and he's currently employed. He works at Home Depot for the past 8 months, making $10 an hour. Would you consider an ROR?
I might. What's your permanent address, sir?
2511 Northeast 8th Terrace, Pompano Beach, Florida.
Northeast 8th Terrace?
Yes, sir.
Okay, this notice says Northeast 8th Street. It's a possibility that the clerk sent the paperwork to a different address. You need to make sure that is correct, because if they send the papers to the wrong address, it's going to be your problem, not theirs. Do you understand? It might be why you didn't appear in court. I don't know. Any record?
No, Judge.
All right, based on the discrepancy in the address and your work history and your stint here in Broward County, I'm going to go out on a limb here, even though a judge has already issued a bond on this case. You need to show up in court, sir, and answer to this trespass charge and get it resolved. Do you understand?
Yes, sir.
It's your obligation to make sure you find out when your court date is and get to the court, okay?
Yes, sir.
I will place you on ROR. You need to appear and answer to the charge. Good luck.
Thank you, sir.
Okay, Michael Crum. Michael?
I've been advised, Your Honor, he bonded.
Bonded, thank you. Nathan Macheski? Nathan?
Yes, Your Honor.
Oh, decline PD, Your Honor.
All right, sir, do you have a private lawyer?
I do not yet. I look to find one.
I didn't hear what you said.
I do not have a private attorney yet. I'm going to get one.
Okay. Well, you're charged with 2 cases today. Possession with intent to sell or deliver cannabis, count 1 and count 2. Give me 1 second. This indicates that they issued a state search warrant from Judge Forth. $1,365.7 grams of processed marijuana for resale purposes were found. Field test positive on marijuana. And then it says that you gave a sworn statement and acknowledged receipt, knowledge of the marijuana in the warehouse. All right, so there's probable cause to believe you may have committed both of these offenses. Are you working?
I am, sir. That was my warehouse and that was my business. I have an automotive detail business.
All right. How long you lived in Broward County?
I have lived in Broward County since 2007, and I've also attended Nova Southeastern and graduated with a business degree in 2010.
Checking that right now.
All right, hang on, sir. We're just checking your record.
No record.
In count 1, your bond is $1,000. In count 2, your bond is $1,000. $2,000 total bonds. You'll have to find a bondsman to help you post that or post it yourself. You'll be released upon that the posting of the bond. Good luck to you, sir.
Thank you, Your Honor.
Marcel Clermont.
Marcel Claremont? Oh, is he the one, is he medical reset or no?
No.
Oh, no, he's coming in, Your Honor. He's out back.
And
Yeah.
he didn't fill out anything. He didn't sign no refusals. He did not release it. That's the one.
Wasn't he just hearing the same thing? He was just here, the same thing, right?
All right, these are serious charges, sir. You- Oh, I'm sorry. You can look up and- Thanks.
Is he able to come? Oh, he's coming.
Go ahead, sir.
He's on his way, Your Honor.
Thank you, Counsel. All right, good afternoon, Mr. Claremont. Mr. Claremont, you're charged with 4 counts today. Count 1, battery on law enforcement or firefighter. Count 2, resisting or obstructing with violence. And count 3, obstructing without violence. And count 4, trespassing in an occupied structure. Do you have a record?
Sorry, Your Honor.
Please don't say
Can you
anything,
repeat
sir.
it? I
Don't say
couldn't hear you.
anything.
All right, hang on, sir, I'll repeat it.
Yeah.
Resisting officer with violence or corruption.
All right, let me repeat myself. Mr. Claremont, you're charged with 4 cases. Case
Yes,
1
sir.
is battery on a law enforcement officer or firefighter. Count 2, resisting an officer or obstructing an officer with violence. Count 3,
Yes, sir.
resisting an officer or obstructing without violence. And count 4,
Yes, sir.
trespassing an occupied structure or convenience. I'm
Judge.
also being told that in case number 147822 that you're on pretrial release for. That case involves an allegation that you also committed a battery on a law enforcement officer.
And Judge, if I may add, per my review of the PC, it seems as if this entire situation was all within the same transaction or occurrence with one officer. And there's case law that says that even if there's multiple officers present, if it's all within the same transaction or occurrence, there would be a double
same
jeopardy
officer.
issue concerning the client
same
being charged
officer.
with resisting with and resisting without violence.
And the one with the other resisting violence is from the county.
Please don't say anything, sir.
All right, hang on, sir. I have a lawyer here representing you in the courtroom, so what I'm going to do
I'm not.
on the without violence is,
I declined the lawyer.
Sir, don't say anything.
I'm not talking about my case.
to alleviate the possible discrepancy on that. Can he be charged, Mr. State Attorney, with resisting with violence and battery of a law enforcement officer, but ROR him on the without? Yes.
I believe he can, but I have no object. Well, yes, you can definitely have the resisting with and without. The issue about the bat Leo on count 1 and count 2.
Well, I'm gonna,
That.
But Your Honor, can you please make notice of the name of the officer? I was just here 2 days ago by the same officer.
right. Well, that's
And
probably
also,
why
I
you're on
also have a
pretrial release.
complaint.
And, well, no, Your Honor, that actually, the listed
That's what
officer.
Mr. Spot.
The listed
I was here
officer.
2 days ago for him.
All right, Mr. Claremont, just hang on a second, please. I'll hear from you in 1 minute.
The listed
Yes,
officer
sir.
in that case is a different deputy.
Yeah.
No, yesterday was Mr. Spot.
Hang on, sir. If his pretrial release is revoked, then I set the bonds on those cases as well.
You can set it at no bond. You can set it at a bond.
I'm gonna set. Yeah, I'm gonna set
No.
the bonds on revoking his pretrial, but because of this new allegation, I'm gonna increase his bond. All right, sir.
But Mr. Hurley, Wednesday was under with the same officer who took me to jail for a misdemeanor, 3 counts, and I had got that reserved.
Okay, well, all I know about the cases that are in
Same
front of me,
officer.
the resisting arrest in this case that's before me right now, the arresting officer is different than the officer that resulted in you being placed on pretrial release. That's what I do know from the courtroom. In case
Okay,
number,
but
hang on, sir.
What-
Case number 147822, your pretrial release is being revoked because of the new charges. In count 1 in that
Yeah.
case, I'm setting the bond at $1,000, and in count 2 in that case, I'm setting the bond at $1,000. In the new case, because of the serious allegations against the police officer and the prior prior allegations that are pending, I'm increasing your bond in count 1 to $2,500. Count 2, the
Right.
bond will be $500. I'm going to ROR you on count 3 because of the potential conflict, and on the trespass, the charge will be the bond will be established at $100. Those will be your
on
bonds.
count 3, what is
Post those
the
bonds and see the
miscap?
judge, sir. Good luck to you.
Count 3, what is the miscap
Down the
though?
middle, out the door.
Count 3 is resisting without violence, and I've ROR'd you on that count. Okay? There's no bond.
Okay, resisting with violence and resisting without. How you get both?
Well, you'll have to sort that out with your judge. Good luck with you. That's exactly what our lawyer here is telling us. All right, Daryl Butler. Daryl.
Decline PD, Your Honor.
All right, Mr. Butler, you've declined the PD. Are you going to hire your own lawyer, sir?
Yes, sir.
All right, you have a whole host of charges here. Listen carefully to me what I tell you what you're charged with. You're charged in count 1 with possession with intent to sell, deliver, or manufacture methamphetamines. Count 2, possession with intent to sell or deliver cocaine. Count 3, cannabis 20 grams or less, possession of cannabis 20 grams or less. Count 4, possession of a controlled substance without a prescription. Count 5, possession of a new legend drug without a prescription. Count 6, a failure to provide liability insurance. Count 7, expired tag. Count 8, driving on an airless tire. That one I haven't heard before. Those are all 3 traffic offenses, sir. So let me take a look at your PC if you'll be patient 1 second, sir.
I had to fix it.
All right, sir. There's probable cause to believe you may have committed all 6 of the offenses to which you're charged. Do we have a record on that?
Your Honor, between 1986 and now, he has 16 prior felony drug offenses. On 11 of them, he's been sentenced to prison.
All right, sir. As I said, in count all 6 counts, I find probable cause. In count 1, your bond is set at $2,500. Count 2, the bond is set at $2,500. Count 3, the bond is $100. Count 4, the bond is $1,000. And count 5, the bond is $25. The 3 traffic offenses, the bonds are 0. You'll have to post those bonds and see the judge. Good luck to you, sir.
Judge, if I may revisit Marcel Clermont. Based on his, my observation of how he interacted with the court, it's my position that I think that he's unable to exhibit good courtroom behavior, and as such, I think that he may be incompetent. There may be some competency issues, more so that ties into his mental health. And I was wondering to see if the court would be inclined to provisionally appoint the Office of Public Defender to represent him, so that he would be appointed counsel in the interim.
Yes, I have no problem with that. No problem with that. Right? I'd be happy to do that. I'll appoint a public defender to represent him for those purposes. Thank you, counsel. Kevin Ragland. Kevin.
We have a
All right, Mr. Ragland, you're charged with 3 cases: possession of cocaine, tampering or fabricating physical evidence, and resisting an officer without violence. Give me 1 second, please.
Trace, you have 3 cases? I see a 2012 cocaine, a Burr conveyance, and then a cocaine from last year. Which third? Okay, let me check that out.
I have to do these related. I'm looking at this. I just got it.
He's showing us 13262 CF10A, standard pretrial agreement entered into September 2nd. Yeah, I will. It's 13262 CF10A. It's just burglary conveyance. Yes.
Okay, there's 5 clear bags of cocaine allegedly seized, weighing 1.6 grams. Field test positive for cocaine.
Hello? Hello? Hi.
All right, there's probable cause to believe you may have committed the 3 offenses to which you're charged, sir. Any record of this gentleman?
I'll give you. Is this the number? Okay.
And 12477 CF10, possession of cocaine and possession of cannabis. The state advise that there's a third case, 13262, CF10A burglary of a conveyance. I'm going to prepare that order right now. Based on the court finding of probable cause, we're going to ask that his pretrial status be revoked. He appears to be in mental health. Typically, we like them to be like
Well, yeah, that was really my recommendation, just because Judge Porth can really decide the best way to proceed, rather than potentially having him on the street committing more offenses.
Okay, are the cases now in front of Judge Porth?
All three of those cases are in front of Judge Porth.
So I'm being asked then to revoke his pretrial status on the underlying cases that he's on pretrial release on, set bonds in those cases, and then set a bond in the case that's currently before.
Well, actually, my recommendation on the cases you're revoking, that they be set in no bond to ensure that he's brought before Judge Porth. Because it's in a specialized division, Judge Porth can decide the best way to proceed, as opposed to, at this point, my concern is with him on the street that he's going to be committing more criminal offenses while this is going on.
No, I'm not sure I'm inclined to just issue a no bond simply because of these drug possession cases.
Well, one of them is a burglary conveyance, and the concern is that there's three of them, so it's continuing while these cases are all pending. He's picking up more and more and more.
Your Honor, do you know what's the year, the date of offense of the three other cases that prosecutor is referring to?
The one that I have in front of me relating to possession of cocaine and possession of cannabis is case number 12477 CF10. The other case is 1316377, possession of cocaine operating without a valid license. And apparently there is a burglary case they're handing me. And there's also a burglary case the year I do not know, counsel. And also a year 13 case here. Oh, they're telling me it's 13262 is what she told me.
It's almost 2015. It's almost over 2 years ago since I've been in trouble.
Well, he's going to have so many bonds here. I mean, he doesn't appear to be a person that's going to be able to, maybe just looking at him with his criminal history, make these bonds. So setting the bonds is essentially a no bond really for him. But I'm not inclined to just no bond him, and I'm not sure that's appropriate on drug charges. So in what I'm going to do, sir, in case number 12477 CF10A, I'm setting your bond in the possession of cocaine case at $1,000 and revoking your pretrial release. In that case also, I'm setting the bond on the possession of cannabis at $500 and revoking your pretrial status in that case. In the other case, 1316377, on the possession of cocaine case, I'm setting your bond at $1,500 and revoking your pretrial release on that charge and setting the bond on operating without a valid driver license at $0. Your two bonds in that case then will be $1,500 and $1,500 on those two cases. In the case that's currently before me, in the possession of cocaine case, I'm setting the bond at $1,000, the tampering with evidence at $1,000, the resisting an officer at $100. Those are the three bonds on the cases that you're charged with here today. And on the burglary of a conveyance, I'm revoking your pretrial status in 13262 CF10A. I'm setting the bond in that case at $2,500. And so therefore you're going to have to post all of these bonds to be enabled to get out of jail. Good luck to you, sir. Have a good day.
So
How about Calvin Bird? Is he there?
Bird? Oh, Your Honor, I was advised Calvin Bird is on medical loan.
Medical reset?
Yes, Your Honor.
All right, reset med.
We have two resets from this morning. Bart.
These resets are over here.
Yep.
How about, some of these we could find the lawyers. Samuel Mosley.
That was a perfection, Judge. I have a supplement. Your Honor, the issue was the public defender objected and Judge Hurley ordered more information regarding how the officer, specific information how the officer received the allegations, the source. So in the supplement, it clearly states that The account of the incident outlined in the affidavit was given by the victim, who went on to provide his tapes recorded statement.
Maybe we'll reset him tomorrow. Thank you. Okay, sir, I know Judge Hurley reviewed your case. You're charged with an aggravated assault with a deadly weapon without intent to kill. There's probable cause to believe you may have committed this offense. The supplemental probable cause affidavit filed by the state today indicates that the defendant subsequently discarded the knife on hearing the approach of the police. The knife was searched for at the scene and not retrieved. The account of the incident outlined in this affidavit was given by the victim, Shatara Ferguson, who went on to provide a tape-recorded statement. So therefore, there's probable cause in this case. Does he have a record?
Your Honor, I'm showing that he has a pending false report of the commission of a crime right now. I'm just checking to see if there's anything else.
How long you lived in Broward County, sir?
Broward County, I lived in Broward County for 9 years, sir. I moved from Miami to Broward since when I was 12.
You working?
No, I'm currently unemployed. I volunteer around my complex. Sometimes when we have enough food, we feed the little homeless or the kids that don't have enough money to eat.
Well, I'm sure you're aware, sir, these are serious charges, and it appears even from the probable cause affidavit that your brother had to stand in between you and the alleged victim in the case, so these are pretty serious allegations. What'd you say about his
Nothing else other than the open misdemeanor, Judge.
All right.
Financially, Your Honor, he has no money in the bank, he owns no property, and he has no source of income coming in, so financially, he's indigent.
Well, whether I set his bond in minimal or leave it where the scheduled bond is, probably will not make any difference. These are pretty serious allegations. Sir, in count one, I set the bond at $5,000. Should you make this bond, you're to have no contact under any circumstances with Shatara Ferguson, who claims to be the victim of this alleged assault. Good luck to you, sir. Have a good day. You can put that with that staple loose. We have another look on Blair Barty. Blair?
Your Honor, this was, the PC was missing the last page.
Oh, yeah. He was from this morning. Yes. All right, Blair Barty. Blair? This was from this morning. We missed a page of your PC.
Blair Barty?
Raleigh Barty.
He was here this morning, and we didn't have a page of his PC. I don't know if they brought him back.
No, he was just here right now. I don't know if he just went to the restroom.
All right.
Barty?
Let's hold his case.
Oh, Barty?
The bond was posted?
That's what...
Okay, you're saying, yeah, he bonded.
Sure what I know, man.
Okay,
All right,
you're
so
right.
We're going to show him his bonded. How about this other kid, Rain Christian Platts? Still there?
Yes, sir.
Mr. Platts, we still cannot get a hold of Mr. Zeidwig despite multiple efforts.
Yes,
as
sir.
I'm informed here, I can go ahead and bond you, and you can try and get a hold of Mr. Zeidwig. I mean, you're charged with an allegation that you violated probation or community control twice. So the likelihood is that you're not going to be released until you see the judge on those. You also have a possession of more than one driver's license charge, which is a minimal charge, honestly. Do you want me to reset your case till tomorrow when Mr. Zeidwig can be here? Do you want me to go ahead and proceed with the bond proceedings without him present? What would be your wish, sir?
I would like to proceed without him.
Okay, sir, in count one, you're charged with possession of having more than one driver's license. Let me just look at this PC. right, sir. Well, you're just in a predicament here. You're going to have to get this sorted out with the judge. There's just nothing I can do. I see that you claimed you didn't know the vehicle was stolen, but the probable cause affidavit and your friends seem to say different things to the police officers at the scene of the arrest. Therefore, in count 1, possession of more than one valid driver's license, your bond is $25. In count 2 and count 3, the violation of probation and community control for being in a possible stolen vehicle, there's no bond. You'll see the judge on December 1st at 8:30. You're going to have to get this sorted out with the judge and get your lawyer there to help you. All right, sir?
Yes, sir. One question. I was charged with the possession of the vehicle.
No, you were
Is
charged
that-
with having more than one driver's license.
Oh, okay. I was just making sure. Thank you.
All right, sir, what is the deal with your elbow that you're holding there? Weren't you the one who told me you were supposed to have surgery?
Yes, sir. I have surgery on Friday. I broke my shoulder. I got jumped last Tuesday, walking back, going from work to my new apartment, and I got beat up. So I went to Broward Health, Imperial Point Hospital, and I told me that I have a fractured shoulder blade.
Okay, well,
The thing is, it's reviewing this. It's not even just the count 1. I'm pretty confident that any felony probation, there's a condition of no alcohol, no drugs, and it appears that he was under the influence.
well, it appears just on the PC that his friends made statements that have gotten him in some trouble here based on him being on probation. Have you seen someone at the jail there, sir, and told them about your arm?
No, I've told them, but nothing has been done or said to me anything.
What's my power with respect to that? I want somebody to look at his arm.
Oh, just, Your Honor, if you order to have a medical screen.
All right, can we do that, please? Okay, on the findings? Okay, sir, based on the way you're holding your shoulder and telling me that you were scheduled for surgery, I'm going to order the jail people to take a look at your situation and see if anything they can do to offer you some comfort until you see the judge. All right, sir?
Thank you very much.
Have a good day, sir.
You too.
All right, I see some more people there, but I don't have any more paperwork.
We got 2 left on the second docket.
Well, these are second looks. All right, I didn't turn my fan on.
Your Honor.
Yes?
One of the gentlemen here requires a Spanish interpreter, Jose Santiago.
He's not on the docket anymore.
We don't even have him on a docket here.
He's on the second look docket?
No, not on ours.
He's Jose Vasquez Santiago.
So I don't know why he was deleted, counsel. I can't help you.
Judge Hurley's, or I don't know his reasoning, but
Hurley looked at it and took him off the docket for a second look.
On some cases, Your Honor, when they come through first look, he'll tell the clerk, and sometimes he'll tell Jay, don't have them come back for a second look. I don't want them coming back for a second look.
Okay.
All right. How about Philippe Walker?
Philippe Walker? No flowers, Your Honor.
Thank you. All right, Mr. Walker, you're here on a second look in your situation. You're charged with possession of methamphetamine or some kind of methamphetamine and possession of a controlled substance. 2 counts. Defense motion for an ROR. So this is a second look. He's in custody. How long you been in custody, sir? It's been 11/16.
Yeah.
11/16. No. So why is he here on a second look? Has he got any kind of extensive record? Is there some reason why he's charged with a felony?
Because he was. I wasn't here the first time he came through, but I do see he's out right now on a theft case.
What?
No.
No, misdemeanor theft.
Let's throw that out.
Well, the 2 cases that he's on second look for, those are both felonies, right?
Yes, he's here today on felony, possession of methamphetamine, controlled substance. I'm just saying,
Controlled
the only thing I see on him, Your Honor, is the pending, without doing a more thorough check, in Broward, he has an open petty theft right now.
That's nothing, man. They throw that out.
So he's had a robbery and a cocaine case already?
That was years ago.
Conditions of release. He was just a med reset?
Yeah, but there were obviously findings, weren't there? Okay.
That's my script, man.
Has he been magistrated already?
Yes.
Oh, okay, sir, we've taken a second look at your case. There's nothing I'm inclined to change based on your criminal history and what I'm being told here in the courtroom. Good luck to you. You'll have to post the bonds that were previously set. All right, back to the main jail. The only other case I have is Stacy Stevens.
Actually, we have. Oh.
Paul Ryan.
Paul Ryan. All right, I'll be right back with you, sir. Stacy Stevens. I'm hitting Paul Ryan, but I'm getting nothing. Oh, there she is. Ms. Stevens, you're on a second look, petty theft, second degree. You were arrested November 19th, it looks like.
Judge.
Yes, Your Honor.
What's her bond? Anybody know?
Wait,
$750.
You have a permanent address, ma'am?
I do, Your Honor. With a year lease.
What?
I'm new. I do with a year lease. I've lived there 6 months.
You work?
I'm new to. No, I'm on Social Security disability.
Does she have a record?
One moment, Your Honor.
Does she qualify for pretrial release if I put her on pretrial release? It's 19.
Fires include 2000 retail theft, 2001 providing false information, 2001 retail theft, 2005 retail theft, 2008 shoplifting, 2010 attempted retail theft. These have all been.
Oh, so she's got a long.
I know she's had at least one theft out of Utah.
Those are all out of Utah,
were they?
Your
Oh, I'm
Honor.
sorry. Oh, well, then
Doesn't
she's
matter
had.
whether it's out of Utah or Alaska. You've
Oh, no,
still-
no, I'm sorry, Judge.
Telling her,
Okay,
she's
okay.
telling me.
Oh, I apologize.
I just.
Ma'am, I can't change your bond when you've got this extensive history. You're obviously not getting the message that you can't just steal from people. So I'm not inclined to change your bond. I'm sorry. I wish I could do something for you over the holidays, but with that lengthy petty theft history and you're charged with it again, you're going to have to post the bond. The bond will stay at $750. Good luck to you, ma'am. Main jail. All right, we still have someone else there, counsel?
Yes, the last person over here would be Vaughn Kinninger.
That was deleted.
I believe it's a municipal ordinance case, Your Honor.
It's a TC case, or at least.
Oh, it's a TC?
What's that?
Oh, I thought you told me
What?
you're here for municipal ordinance.
I am. What is it? What did he say?
Prosecutor said you're here for a traffic criminal.
No, it's I cleaned tires and windows at the stoplight.
What's he charged with?
Checking that right now, Judge.
All right.
Hold on, the prosecutor's looking into it, but he's very thorough before he says
No,
anything,
this
so I'm
is
pretty sure he's confident.
This is a capias on a TC case, obstructing traffic. It's a $250 bond. I frankly don't remember when it first came through. I just know this is another one of those that Judge Charlie said he didn't want it coming back for a second look. Probably because this is.
Has he been appointed, Mr. Shea?
Well, no, he would have the PD. It's not a municipal ordinance. Some of Judge Charlie's reasoning could have been since June of 2012. This is his 9th arrest.
9th arrest since June 12th.
But 2012.
And he didn't appear on
Since 2012.
No, it's here in the capias.
Okay, your bond remains at $250, sir. Good luck to you.
Can I ask him?
Your Honor, Mr. Kinninger has one request.
Yes, sir?
Your Honor, I know that I can't change the past ones that led up to this, but I hadn't had one in a while, and I was cleaning the tires.
Don't talk about the facts.
I was at the.
Don't talk. Tell him whatever you want about letting him go, but.
I hadn't had one in a while. I was trying to. Wondering if I could resolve it today, sir.
It's a state case.
I don't know anything about it.
I don't have your paperwork up here, sir. Do you have the capability, if I reduce your bond to $100, to make the bond, sir?
No, I don't.
I can.
Not at this point. An OOR, I do. Our
had
mailing
about
address.
3 or 4 prior capiases that I can see.
I need to tell him one. Tell me to tell him one.
I understand. If you want to reset it,
We got 2 mailing
Take his
addresses.
case and sentence him to a couple days in jail. And
if the court's inclined, I mean, I'm not going to stand in
All
the
right,
way
sir.
of the court.
Sir.
19 listen.
It's not. I can give you
Sometimes-
the case information.
Yeah, what is We don't have any paperwork is the problem. I would resolve your
You
case.
can reset it for tomorrow if you'd like, Judge.
Well, I can set it
No
first thing
permit.
in the morning, and I'd be
Morning,
inclined to resolve
yeah.
your case, sir, in some way,
Do it tomorrow
maybe
morning.
sentence you to a couple days in jail
I'll,
and resolve your case so
I've
you don't
done
have to
6.
sit there on bond.
and Your Honor, if you want, as an officer of the court, I'll let
If you
Judge
wanted to
Hurley know
resolve
what the
it,
offer you
All right,
you
you
could probably get
understand?
time, sir.
You understand?
Yes.
Okay.
Yes.
We don't have any paperwork, so what I'm gonna do is, I'm gonna advise the state attorney here that Judge Hurley's gonna hear your case tomorrow, whoever will be here. And my recommendation is that I adjudicate you on the charge and sentence you to 2 days in the jail and resolve your case. Okay, then I don't have to worry about the bond issue or you coming back. If that's not what you wanna do, you'll tell the public defender tomorrow, but I'm gonna give you an opportunity to resolve your case, but without any paperwork, I cannot do it this afternoon, but I'll put it on the morning docket at 8:30. All right?
Thank you.
He can't resolve it?
He doesn't have paperwork. He's going to put it on for tomorrow morning. Okay?
All right.
I'll explain it to him.
And we'll give him credit for
Thank
today,
you.
so one way or the other, if we resolve it that way, he'll get credit for today.
All day?
Yeah.
I've
Sure, you
been
got it
6.
2 days.
Yeah, he's been in for 6 days in custody, so
All right, well, I'd
it'll be a
inclined
time
to
served.
Probably let him go on time served based on that. All right, but I'll let Judge Hurley deal
Thank
with it
you.
in the morning, but I'll put it on at 8:30.
Thank you very much. I'll let Mr. Or Mr. Linder, you'll let Mr. Hurley know
I'll make
tomorrow.
sure
I
the
won't
judge
be here.
knows.
Yeah, he's gonna let the
To
judge-
represent correctly.
Hector, I'll be here in the morning as well.
All right, both our lawyers
All
will
right,
be
thank you
here.
very much.
All right, good luck to you, sir.
Appreciate
Thank
it.
you.
Bye-bye.
Any further counsel from the courtroom?
That is all. Thank you very much, Your Honor.
Have a good
Appreciate
Thanksgiving,
it.
sir.
You too.
All right, that's it, folks.
Thank you, Judge.
We did it without fanfare.